Jack Smith's Deposition Part 18. Defense, GOP Concerns, SCIF, and a Speedy Trial. Welcome to Law and Society. Please remember to subscribe. What I'm doing right now is reading you digestible sections of Jack Smith's deposition in the House Judiciary Committee. And the reason why I'm doing it is because it is important for every American to be reminded and keep remembering that Donald Trump incited an insurrection on January 6th, and along with that, Donald Trump conspired to defraud the United States and all of us of our right to vote. No matter what Donald Trump and his loyalists keep saying to rewrite this history, we must, the rest of us, hold this history to be the truth and never let go of the fact of what Donald Trump did or tried to do to our republic. So with that, I'm going to start reading the questions, and then I'll read Jack Smith's answers. Here we go. Question. In conjunction with your final report, a letter was prepared by President Trump's defense counsel, Todd Blanche and John Lauro, and they raise issues concerning the review of the report over Christmas season. And they indicate that they were placed in a veritable hardship trying to review the report because the special counsel's office required them to come to D.C. The special counsel's office wouldn't let them, use their laptop. They wouldn't, have access to any, internet. Can you walk us through your posture on some of these onerous conditions that defense counsel raises? So you can tell this is a Republican question. So, Smith, I recall being surprised and disappointed about their letter on that point, because my recollection is that we, and I'm not going to remember the specific dates, but I remember that we gave them a time period and conditions to look at the report, and it was around the Christmas holidays, and they were unhappy with those conditions, and we then changed the conditions to better suit what they wanted. And I remember them expressing appreciation to us for allowing them to change the schedule. That's my recollection of that. When they complained about the schedule, I remember being surprised about that. The deletion of discovery, that was pursuant to the protective order in the case. And so, put aside the final report of their review, the protective order that both parties signed, and again, there was record of this. That protective order stated that when cases were concluded, the discovery had to be deleted. Question. What type of communications did you or your staff have with the January 6th committee? Smith. So when I was appointed as special counsel, I asked at some point whether we had gotten evidence from the select committee. We had not. So I directed my staff to get that evidence, get whatever evidence we could from them. And I think it was in December or so that we did in fact get evidence from them and get a copy of their final report. The stuff we got from January 6th committee, I directed my staff to disclose it to the defense. Question. And when it comes to deleting documents, while the Republicans didn't do that, what can you tell, what I can tell you is that the January 6th committee files, when they were able to have access to them, did not include the videos that they recorded. Do you know if the special counsel's office took possession of the videos of the interviews? Because we didn't get it. They were gone by the time we had access to it. Smith, as I sit here now, I don't know. What I recall is, give us everything you can. Give us any evidence you can. And then we reviewed that evidence and disclosed it to the defense. Question. If a SCIF was established, this isn't just any normal person. This is the former president of the United States, now current president of the United States. And if a SCIF, which is a secured, confidential, secret something, it's a super secret location or secure location. And if a SCIF could be recommissioned at the Mar-a-Lago residence, why would you have an issue with that? Smith, well, I think you just hit on it. Any normal person, he should have the same rules as everybody else. And he, at this time, was a private citizen. And I'm not aware of any private person in the litigation, no matter how important a person they are, no matter how busy they are, being allowed to have a SCIF in their home for their convenience. I think we worked to make his review of classified documents at the SCIF in Miami more convenient, and we did that. But I did not think it was appropriate because I think he should be treated like anybody else. The MAGA party doesn't like that, remember. Question: how quickly did you want to proceed to trial after that case had been indicted? Smith: I'm going to guess 4 months. Question: but do you think in hindsight that 4 or 5 months after when the indictments dropped, was it pretty aggressive timeline, wasn't it? Smith: we organized the discovery in a way that we felt that that was a fair date. Question: how many hours of video footage? If the defense was going to take that to trial, in 4 months, how many hours of footage would they need to digest? President Trump's defense team, it was indicated that like thousands of hours of video, digest 13 million pages of documents, would have put them in a situation either A, not review the documents, or B, look at like 100,000 pages per day. I mean, do you think that's reasonable? Smith: I thought the trial date that we proposed, given the case, given the discovery, was reasonable, yes. We also deferred to the judges. So when we asked for a date and the judge picked a different date, I don't recall we objected to that date. Question: do you think in hindsight that you exhibited kindness in dealing with President Trump that Robert Jackson evinces here? Smith: I think in our conducting both these investigations, we did consistent with the best traditions of the department and the principles that Justice Jackson was talking about there. So yes, I do think in both cases we adhered to those principles. We were trying to move those cases expeditiously. In our briefs, we cited to repeated Supreme Court precedent that states that the interest in a speedy trial, the right to a speedy trial, isn't just the defendant's right. It's the public's right as well. And given the gravity of these crimes and the public interest, it was our duty to move them forward as expeditiously as we thought fair and reasonable. So with that, we come to the end of section 18 of Jack Smith's deposition. Please remember to share this information, like it, and remember to subscribe. There are 2 more episodes that I have recorded for Jack Smith's depositions, so please stick around for them. They will be premiering soon. With that said, thank you for listening. Take care, everybody.